Good morning. Are you Anthony Whitmire?
Yes, ma'am. Good morning, Your Honor.
And Mr. Rojas, will your client with the formal reading of the indictment?
He will, Your Honor.
Mr. Whitmire, in cause number 25 DCCR 0057, you're charged with the second-degree felony offense of possession of a controlled substance from October 12th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Whitmire is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I'm going to sign a dismissal as part of this plea agreement and clause number 25 DCCR 0056. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Just thinking about yesterday, and this is a possession case, so I'm not sure how it applies. But because of the judgment entered against you, you could be ineligible to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas and read that document carefully. All right, you can go back with the bailiff.
Thank you.
Good morning. Are you Brendan Ernest? And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
Right, Mr. Ernest, in cause number 26 DCCR 0429, you're charged with the first-degree felony offense of aggravated robbery, and that's from February 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? Then, let me take a second. And cause number 26 DCCR 0430. You're charged with a third-degree felony offense of obstruction or retaliation from February 12th of 2026. And how do you plead to that charge?
Good.
Again, are you pleading guilty freely and voluntarily? And because you did what they've charged you with? In cause number 26 DCCR 0908, you're charged with the second-degree felony offense of robbery, and that's from February 12th of 2020. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? In all three of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you made with the district attorney that you will be waiving or giving up any right to appeal?
Yes.
So you can't change your mind if I follow the agreement. You understand?
Yes.
And it looks like the agreement that you've reached in all of these cases would be for 10-year deferred probations. There would be $500 fines in each case. There would be a dismissal in cause number 26 DCCR 0431, and you would be required to follow all the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Ernest is not competent?
No, Your Honor.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
Yeah.
All right, you can go back with the bailiff. Good morning, ma'am.
Good morning.
Good morning, Judge West.
Good morning, Mr. Norris. How are you doing?
You know who this is, don't you?
Yep, I know who you are. You're Christopher Norris, right?
Yes, Christopher Stevens Norris.
All right, so this is cause number,
Yeah.
hang on just a second. Let me go through some stuff. If you have something to say, I'll give you an opportunity, okay?
Okay.
And you should be able to see on your screen, Mr. Rojas is here, your attorney in court. Mr. Nichols is here representing the state, and this is cause number 0184078. And Mr. Norris was found not guilty by reason of insanity of the offense of murder back in February of 2006, is currently at the Russ State Hospital. And this is our yearly hearing under Article 46C of the Code of Criminal Procedure. I am going to take judicial notice of the court's file, including all of the previous hearings and reports. In addition, I have received the most recent report. I have a forensic psychiatry report to the court, which was prepared by Dr. Gerke, dated June 10th of 2026. The finding in that is that Mr. Norris, that further inpatient treatment would be recommended, and that it is not recommended that he be released to live independently at this time. And then in addition to that, I have a physician's certificate of medical examination for mental illness from Dr. Gerke. The finding in that is also that Mr. Norris is mentally ill, that without inpatient treatment likely to cause serious harm to others. And there's several notations here with some issues that have occurred between now and our last hearing a year ago. Is there any other evidence with regard to further treatment inpatient at this time, Mr. Rojas?
No, Your Honor.
Mr. Nichols? Give me just a second to, all right. Then I am going to find at this time, based on the reports, that Mr. Norris is mentally ill and that, further inpatient treatment is required, based on I'm sorry, I'm trying to read and talk at the same time. That he does not meet the traditional civil criteria for recommitment, but based on his current forensic type commitment, continued inpatient treatment is required because of the acquittal by reason of insanity with regard to the charge of murder. And that the specific finding is that without that, he would be likely to cause serious harm to others. And therefore, I am going to order the 1-year commitment And
give me no time to
I've
talk.
heard-
Like you told me, I have plenty of paper here I want to explain to you. You know that I have been locked up for 5 years, 8/13/2021 to 8/13/2026. I've been locked up 5 years. On August 13, 2026, I'll be locked up for 5 years exactly.
So, Mr. Norris, here's the thing. We tried several years back.
No,
I, in fact,
that was 5
hold
years
on.
back.
Yep, and that did not go well. And so all I can do at this time is base my decision on the history and the fact that I did, based on, at that time, it was everyone's recommendation that you be released to a kind of an outpatient, more relaxed situation, and that did
Yeah,
not work.
I was
And
on
so I
a
ordered you
step
back
down
to Russ.
program. I got paperwork showing it says, while I was at Russ Hospital, I take my meds, take all my meds, learn everything about meds and symptoms, learn my strengths and weaknesses, focus on mental health, take meds, keep appointments. I mean, I do everything that I'm supposed to be doing this year for
Well,
sure.
and here,
Work on my goals while I was at this hospital. I've been working on my goals. I understand that mental illness diagnosis is lifelong. Recognizing my symptoms when they are active. I mean, I got plenty. So I'm on resources, housing, transportation, food, clothing, support, medical service. I mean, I got all kind of stuff right here saying that I've been doing, in the community, stay away from drugs and alcohol, stay in touch with court. I know that I gotta stay in touch with you if I get out because I know that
so
you
Mr.
know
Norris,
charge.
let me interrupt you real quick, Mr. Norris. I can tell you now that if the doctors are not recommending that you be
Yeah,
released,
I
then
really
I'm not,
consider. I haven't talked to that doctor for almost 6 months.
Mr. Norris,
I've been asking for another doctor, and what he wrote up was 6 months back because I've been trying to get another doctor.
I've made my ruling at this time.
What is your ruling?
My ruling is that you're going to be continued inpatient at that facility until further order of the court. If something happens and the doctors recommend some other outpatient or
What if I don't feel safe at this facility anymore? What if I don't feel safe here no more?
then you need to talk to that facility. I'll talk to Mr. Rojas and we'll look into it. All right? The hearing's over. Thank you.
Yeah, it's wrong though. It's wrong. That's all right.
All right. Keep doing what you're supposed to do and potentially in some
I
time in the
have
future.
been doing what I'm supposed to be doing. I have been doing what I'm supposed to be doing.
Well, all right.
That's what I'm trying to tell you right now.
I understand. Continue to do that, okay?
So you just, anything anybody else tells you, or you pull up, and it doesn't even make sense what you said about the doctor overruling. I haven't seen it for 6 months. How can you write all this stuff about me?
We'll look into that, but the report that I have is dated June 10th, and so that's what I have to go by. And so I'm going to again, I've made my decision.
That's gonna be
And
your decision every time I come in front of you. I don't feel safe at this hospital.
okay,
That's what I'm
we'll
trying to
check
tell
into
you.
that. All right, thank you. We'll check
You
into
never
that.
check into it because you don't know.
Good morning. Are you Joseph Roberts?
Yes, ma'am, good one.
Good morning. This is 20-34226. Mr. Roberts. Looks like you were on probation for the felony offense of driving while intoxicated, and that you were placed on probation November 30th of 2020. That was a 7-year term in prison that was probated for 7 years. Some of the allegations, it looks like there is an additional driving while intoxicated charge from April 26th of 2026. Curfew issue, operating a vehicle without an ignition interlock device, and then some minor fees. Mr. Nix has filed a motion asking that I set bond in your cases. Currently, there is no bond. He's also handed me, it looks like there was a 30-day treatment at Level Up Treatment, Texas. That you went to April 26th through May 29th of this year. Mr. Roberts, best you can, raise your right hand, please, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. Mr. Nix?
Your Honor, we'd ask that the court set a reasonable bond. My client's willing to forfeit his right to drive. He would wear a SCRAM device, comply with any curfew set by the court. As the court can see, he did not have any issues on the probation for several years until he picked up this new offense. It was not his vehicle. There were several other occupants in the vehicle, which would explain why he wasn't complying with the interlock device. He obviously knows that he made a pretty terrible mistake. And if the court will acknowledge, just 3 days after his arrest, he voluntarily did a month of inpatient rehabilitation. Also, I'd like the court to take knowledge of, and although I didn't put it in my motion, I think we've made the court aware with the district attorney. His daughter was brutally murdered about 10 days ago now, somewhere around there.
2 weeks.
About 2 weeks ago. His daughter's funeral is this Saturday. She was the victim of one of our homicides here in Beaumont out of a domestic violence situation with what appears to be a boyfriend or ex-boyfriend. He'd like to, be obviously on bail so that he can attend his daughter's funeral. He would adhere to any recommendations, anything that the court requires of him of his bond. He's also just been accepted into an IOP program where he will be doing counseling therapy for alcohol, substance abuse. As part of that program, they do random alcohol and drug tests. This is something that his insurance offered him after finding out about his daughter. So not exactly related to the DWI, but it's related to finding out that his daughter was murdered in the way she was murdered. He's taking advantage of that. Obviously, he doesn't want to have an episode where he falls off given what his family's going through. He is not the sole provider of his family, but he is the main provider of his family. They have 2 homes, one home that they live in, another home that they haven't been able to sell. So they have 2 mortgages to pay for and bills. Is that correct, Mr.
Yes, sir.
And right now I'd ask if Mr. Roberts can give more details to the IOP than I might be able to. Can you explain to the judge?
What's the name of it, or where is it? What's it through?
It's Trust Health,
Trust.
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 Yes, ma'am. We do 3-hour sessions, 3 days a week.
Is it on,
That's a group.
is it
I
online?
do
or
it
in
virtual.
person?
I do virtual. Yes, ma'am. They do the random drug screening once a week, and we get a therapy session with a counselor also throughout the week.
How do you do your random drug screen?
They send an Uber and bring me to Quest on 9th Avenue. So
Have you already done one of those?
I have one set up for tomorrow.
Okay.
Yeah.
Where do you work?
There you go.
With Bechtel, Environmental Safety and Health Representative with Bechtel. For out there, LNG.
So how would you get to and from work and things like that if you're not going to drive?
Yeah, my nephew also works out there, same shift, so I can ride with him.
Just for the record, I am reviewing the court's file, and part of that does include the probable cause affidavit for the new driving while intoxicated. I was looking to see, but I don't know that
It's not yet been received, Your Honor. Testing has not yet been completed.
I was trying to also see, do you have a copy of that previous pre-sentence report?
I had it on my computer earlier, Your Honor, to pull it back up.
Ours didn't, because it's an older case, it's not in here. Okay, please, ma'am. I guess an issue that I have that we're gonna have to talk about. So Mr. Roberts signed a no driving agreement with probation March 19th. And then the allegations are that a month and a week after when this happened, he was driving. So he'd already told someone and signed an actual document saying he wasn't going to drive. So obviously the argument of I'm not going to drive gives me some concern because you already have been there, done that.
How many set of keys do you own?
Many.
No, to your
No,
car,
oh, I can have one, my wife have one.
for the same car?
Yes, sir.
We'd be willing to turn over both sets of keys.
Wasn't driving his car on this date.
Fair enough, Judge.
So I'm not saying I'm not going to set it a bond, but these are the concerns that obviously there was something going on that I'm not quite sure about, but obviously there was something going on for there to be a no motor vehicle drive form
Yes, ma'am.
signed a month before. So there were some concerns already.
I have a previous PSI. for
Sounds
that.
like it's coming as well over here. Thank you, Mr. Nichols.
Take it.
Mr. Nichols, what's your position?
Judge, I'd reviewed Ms. Molfino's email correspondence with the court and with Mr. Nix talking about her position on this case. We are not opposed to a reasonable bond being set. Obviously, we have concerns, same as the court with the driving. I believe a SCRAM will take care of any concerns about substance abuse, but there's just not an easy way to be completely certain about the driving. Given the circumstances, given his willingness to do what he's already done and what he's going through, that's why the state does agree for a reasonable bond in this case, Your Honor.
Okay, so Mr. Roberts, I want to make sure you understand, I'm going to set a bond, and if you make that bond, there'll be some very specific conditions. Some of those conditions are conditions you already have on the probation. At this point, I understand that you're going through something very traumatic in your life, which tends to lead for people who have substance abuse or alcohol issues for those to get worse. If you don't take advantage of this opportunity while you're out on bond, I can assure you, you're not going to get any opportunity. You're going to be back in jail and you're going to be looking at going to prison for the 7 years that you've already agreed to on that underlying case and who knows what on the other. So this is make it or break it, going to prison type thing, even though it's just a bond. Do you understand?
Yes, ma'am.
So what I'm going to do is grant the motion to set a bond in cause number 20-34226. I'm going to set the bond at $25,000. I am going to order as a condition of that bond that you wear a SCRAM device at all times. If there is a positive alcohol screening, I will know about it. There will be a warrant. There will be no bond, and we'll be looking at that 7 years. It's that simple. Also, as a condition of that bond, you are not to drive any vehicle ever, period, under any circumstance. If you're with people and they're drinking, then you're not the one that drives. Y'all walk, y'all get an Uber, you do something else. You understand? Also, I am going to order as a condition of your bond that you, and really I want it to be a condition of probation as well, to modify your conditions of the probation you're currently on, to order that you can continue that program, the IOP, through Trust Health. I want proof of that, verification of that, since your probation officer each week or whatever you can do. If it's online, you should be able to print something out to send to them to show that you're doing the 3-hour meetings, as well as any drug or alcohol screen that you get done. You need to get those results also to your probation officer. Okay.
Yes, ma'am.
So that'll be a condition of bond as well as your probation. Any other conditions that I didn't cover?
Those are the ones that I was concerned about. I think that'll cover it.
Okay. All right. So what we'll do, if you make that bond, you'll have another court date set. Stay in touch with Mr. Nick. He'll let you know when you need to be back here and in court. And again, whatever you need to take care of to keep yourself doing the right thing, going through what you're going through, you need to make sure and get that done. Because being in prison won't help the rest of your family. Okay, all right.
Thank
Yeah,
you,
that-
Judge.
Yes, sir. I'll shoot a message over. to Judge
Thank you. I
Townsend.
appreciate it.
As this hearing comes to a close, it's important to understand exactly what happened here. After reviewing the medical evaluations, forensic psychiatric reports, and the full case history, the judge determined that the legal standard for continued inpatient treatment had been met. Although Mr. Norris expressed frustration, explained the progress he believes he has made, and questioned how recent the doctor's evaluation was, the court emphasized that judges must base their decisions on the official evidence and recommendations before them, not personal opinions or hopes for a different outcome. In cases involving a verdict of not guilty by reason of insanity, the court's primary responsibility is balancing the individual's rights with public safety, making these hearings some of the most difficult decisions in the justice system. Now we want to hear from you. Do you think the judge made the right decision based on the evidence presented, or should Mr. Norris have been given another opportunity? Share your thoughts respectfully in the comments below. If you found this courtroom case insightful, make sure to hit the like button, share this video with others interested in real courtroom proceedings, and don't forget to subscribe for more in-depth courtroom breakdowns, legal analysis, and true courtroom stories. We'll see you in the next case.